Thanks.
Right, it's 6 o'clock, so good evening and welcome to this meeting of South Oxfordshire District Council's Planning Committee. I am Councillor David Brotherson. I'll be chairing this meeting. May I remind everyone that this is a meeting in public, not a public meeting. Only members of the public who've registered to speak are allowed to do so. I will call on them to speak during the appropriate agenda item. This meeting is being held in our offices in Abbey House, Abingdon. Committee members are here in person, but officers and speakers are able to join remotely. The meeting is being streamed live on the Council's YouTube channel for public viewing. This system allows councillors unable to attend in person to contribute to the meeting, but only councillors who are present in the room are allowed to vote. The speakers and members of the public have joined remotely. Please ensure that your microphone is muted and that your camera is off for the duration of the meeting until you are called to speak. Can I ask everyone to put the cameras on to please turn them off? Yes, please turn your camera off. The Planning Committee is a decision-making committee of the Council, and it is important that a set procedure is followed. All committee members have received a full report on each planning application, either on paper or electronically, and it should be noted that committee members and officers may be using electronic devices for reference throughout the meeting. For each application, we'll first hear from the planning officer, followed by parish or town council, and then objectors, supporters and local members. Each group will have 5 minutes to speak to the committee, after which members may ask questions of the speaker. The committee will then ask questions for clarification of the planning officer. The committee will then debate and vote on the application. Councillors wishing to ask a question or participate in the debate are asked to indicate this by alerting myself or officers by raising a hand. Voting will be by show of hands. Members, please place your hand clearly and keep it raised to allow count to take place. If it's unclear how members are voting through a show of hands, I'll ask the clerk to undertake a roll call of those present and how they are voting. A few housekeeping announcements. In the event of emergency, please evacuate the building by the nearest exit, which is in the corridor immediately to the right of this meeting room, and go to assembly point 9 in the outside area beyond the fire exit. The Democratic Services Officer here present will assist you. Can everyone please ensure that their mobile phone is switched to silent or switched off during the meeting, which is the point where I switch my phone off. Members of the public who wish to leave the meeting after their application has been heard are welcome to do so by the front door in reception. When the meeting is finished, I will ask for confirmation that the live stream has ended. At that point, please leave the meeting and make your way to out of the building, remembering to sign out as you leave. So that was agenda item. That was item 1 on the agenda. Item 2 on the agenda is apologies for absence. I'll go to the committee officer.
Thank you, Chair. We've received apologies from Councillors Keats Rohan and Councillor Norman.
Thank you. At this point, I'd like to actually welcome Councillor Higgins for his first planning committee meeting. Probably his first meeting in the council, really.
Thank you very much. Pleasure to be here.
Yeah. Minutes of the previous meeting to adopt and sign as a correct record the planning committee minutes of the meeting held on the 7th of May. I have a proposal. Thank you. Is that seconded? All those in favour, please show. Thank you. This is a difficult bit. Declaration of interest. To receive declarations of disposable pecuniary interest, other registrable interests and non-registrable interests, or any conflicts of interest in respect of items on the agenda for this meeting. I see none. That's good. Urgent business. Is there any urgent business?
No urgent business.
No urgent business. Public participation. Okay, so we now move to the planning applications. And the public participation we will take as we go through the planning applications. So the first one on our agenda is, got it right, B24 S2700 S73, Cedar Lodge Care Home, Eastfield Lane, Whitchurch on Thames, and the planning officer is Sarah Cheshire. So Sarah, can you take it, please?
Thank you, Chair. This is an application under section 73A of the Town and Country Planning Act seeking consent to vary conditions 3, 11 and 14 of Planning Commission S23 S4055 S73. I have a couple of verbal updates. The first relates to the application description, which is amended to refer to section 73 of the Act in order to clarify that the application is retrospective. The other updates relate to the detailed wording of conditions in Appendix 5 of the committee report, which I'll come on to later in my presentation, but I have hard copies to circulate so that members have the detailed wording in front of them. Got a few more copies here if members of the public want to. The application seeks retrospective planning permission for amendments to the approved development to change the design of the extension and the landscaping of the site. The application site is Cedar Lodge, formerly known as Eastfield Lodge, which is located on Eastfield Lane towards the southern edge of Whitchurch-on-Thames. The site location plan. The application site is located in Whitchurch-on-Thames conservation area, and the building is a non-designated heritage asset. The site is also located in the Chilterns National Landscape. There are trees both within and adjacent to the site, all of which are protected by virtue of their location in the conservation area, and some of which are protected by tree preservation orders. This photo shows the view of the site from Eastfield Lane, with the approved extension just visible to the rear of the original building in the left-hand corner. And the site plan shows the extent of the approved extension. So that's the wider part to the rear of the building. This was the footprint of the original building. So planning permission was granted on appeal for substantial extensions to the original building in 2013. That permission was implemented, and subsequently a section 73 application was approved and granted permission for changes to landscaping and tree protection measures. The changes for which consent are sought as part of the current application before the committee comprise amendments to the roof of the approved rear extension, comprising an alteration from a hip to a half-hipped northeast wing. So that's in this part of the site up here. A raising of the eaves height of the approved extension and the associated alterations to gables on the extension. The reconfiguration of approved dormers and the addition of 2 dormers to the front and 1 dormer to the rear roof slopes of the extension. Changes to the roof of the lift overrun and the relocation of approved roof lights. And alterations to the external terrace, which is in this part of the site here between the original building and the approved extension, including the introduction of access to an undercroft beneath the terrace and the installation of plant within the undercroft. And finally, amendments to the approved landscaping to coordinate the landscaping with the external changes to the building. There's no change to the overall footprint of the appeal scheme as a result of the changes. So this shows the south elevation. That was what we saw in the photograph. This was the scheme approved on appeal, showing the hipped roof to the extension to the rear there. And then this is what's proposed as part of this application, the half-hipped roof there. And also the change to the roof of the lift overrun from a pitched roof here to a flat roof, and two dormers instead of 1 here, where there was previously 1. And you can't see that clearly, but this also shows the slight increase in the eaves height between the approved scheme and the proposed scheme. This is the east elevation, again showing the approved scheme with the fully hipped roof to the eastern wing of the extension, and the proposed scheme with the half hip, and again the change in roof from a pitched roof to a flat roof on the lift overrun. And this is showing the location of the extended terrace and the undercroft plant room just at the bottom here. So this is a photo showing the half-hipped roof from the front of the building. This is taken just to the right of the original building. That's what's shown in the foreground, and showing the end of that wing of the extension with the half-hipped roof. This is a view of the eastern side of the site from the front garden of Eastfield Cottage, which is the property to the east located just down here. This is a view of the site from the rear garden of Eastfield Cottage, from the ground floor windows of Eastfield Cottage, and the first floor windows. This is a view again of the eastern side of the site from Little Eastfield, which is the property just here, located further to the east. So that's Eastfield Cottage in the foreground, and then the half-hipped roof just visible over the conservatory there. And again, a view from the rear garden of Little Eastfield, showing that eastern elevation with the half-hipped roof. Moving on, this is the approved and proposed west elevations. So the main change here, we saw previously that there's now 2 dormers where there was previously 1 on the front roof slope of that extension. And this roof light here has also been removed. So that's a photograph showing those reconfigured dormers. And then a photograph of the same part of the building. That's from the garden of Eastfield Lodge, which is the property down here to the southwest. And then that's a view of the rear elevation from the garden of Tanglewood, which is the property up here. So there's some additional dormers on this rear roof slope, but they're screened by those trees, so you can't see them clearly in this photograph. So again, looking at the approved and proposed elevations, the main change on this elevation is the additional dormers. So there are 5 shown on the rear roof slope on the approved plans, and 7, and they're slightly reconfigured on the proposed elevations. And then that's a photograph showing the view of the rear elevation. I'll now go through the floor plans and highlight the areas where changes are consent for changes are sought. So this is the lower ground floor plan. This shows the Undercroft plant room just here. The approved ground floor plan and the proposed ground floor plan. So the main change is this extension to this terrace in the east here. The first floor plan, the changes here are internal only. The second floor plan, the main change is the small additional area of floor space that's created in the east of the second floor, which is as a result of that change from a fully hipped to a half-hipped roof. And then the approved and proposed roof plan. So again, that just shows the change from a fully hipped roof on the eastern wing there to a half-hip. And that shows the location of the reconfigured dormers. As I mentioned earlier, I have an update following the publication of the committee report and appendices. Recommended conditions are set out in Appendix 5, and a number of changes to detailed wording of conditions is recommended. You've got properly detailed wording in front of you. So I'll just talk through the changes. The first is to condition 1. That condition is no longer necessary as the development has commenced. The changes to condition 7, details of external lighting have already been approved by a discharge of condition application, but some additional wording is recommended just to clarify that any alternative details would require further discharge of condition application to be submitted to the council. Condition 15, some additional wording is added just to clarify the prohibited uses of the terrace and to prevent the placing of seating on the terrace. Condition 17, some additional wording is added, that's just in italics on the slide, which is to clarify the specific noise limit that external plant would have to comply with. And that's just to bring it into consistency with the condition relating to internal plants. And finally, the wording for condition 18, it's proposed to require that the external plant that doesn't have permission is removed prior to occupation of the development rather than within 1 month of permission. And finally, an informative is recommended just to clarify that those elements of the development which aren't shown on the submitted plans, which specifically is referring to the external plant which doesn't have consent, would not benefit from permission as a result of this decision. Officers have considered the impact of the changes on the surrounding properties very carefully. In respect of the Undercroft plant room and associated plant, officers are satisfied that, subject to the recommended condition restricting the use of the external terrace, The increase in the area of the terrace would not result in any harmful impacts of overlooking, loss of privacy, perception of overlooking, or noise and disturbance to neighbouring properties. Officers are satisfied that noise impacts from the internal plant can be mitigated by the recommended conditions, which include a requirement to install additional noise mitigation should it be required to achieve an acceptable noise environment. External plant is not considered as part of this application, but a condition is recommended requiring the removal of unauthorised plant and the submission and approval of details of any external plant if it is to be installed. In respect of all other changes to the extension, including the change to the roof from a hip to a half hip, having visited the site, considered the inspector's assessment in the appeal decision and reviewed the findings of the daylight and sunlight assessment, officers are satisfied that the changes for which permission are sought would not result in a harmful loss of daylight or outlook, would not result in a harmful impact of overbearing, and would not result in a harmful loss of privacy or result in a harmful perception of overlooking. Subject to the condition requiring certain windows to be obscure, glazed and fixed shut, the changes would be acceptable in respect of their impact on amenity. The changes would not be out of keeping with the character and appearance of the area and would not result in harm to the conservation area or to the original building, which is a non-designated heritage asset. The changes to landscaping are necessary to reflect the changes to the building and would have an acceptable appearance and help to assimilate the development into its surroundings. The changes to development would not result in any impacts to the Chilterns National Landscape or to protected trees. And subject to the recommended condition, the application would secure adequate mitigation and enhancement.
Vice Chair Whitchurch-on-Thames Parish Council.
Where would you like me to go?
To the table, please. Yeah.
I'll stand here. Right.
Prefer to stand. That's okay.
Yeah.
Yeah. Okay. Okay. You have 5 minutes starting from when you start.
5. Thought I had 3, so it'll be rather shorter than you might expect. Right. So I am speaking on behalf of the Whitchurch-on-Thames Parish Council, and the tale of this development began as far back as 2005 with the topographical survey. Since then, the parish council and residents have been subject to around 30 notices on this site, and there have been 2 appeals, one successful and one rejected. After complete demolition was refused, the previous owners returned to the consenting plant, which was around 2013, which the present owners took over in December 2022 when they bought the building. Many residents who objected to the plans felt worn down and accepted that a large, dominating 45-bed capacity care home would be built, despite it being out of place in this conservation area. Whitchurch-on-Thames is a small rural village, not a big city, where it's common for large buildings to dominate smaller ones. Other new developments of the lane are fitted in reasonably well. The fully hip roof on the east of the rear extension would help to mitigate the looming presence of this building on near neighbours. Since September 2024, 37 residents have objected to this S73 application, 16 of which live in Eastfield Lane, and there were no supporters. The PC support the objection to the half-hip roof, the additional windows on the south side of the new extension, which overlook the garden and rear of Eastfield Lodge, and the location of the plant room to the undercroft rather than the upper floor. We are doubtful about the accuracy of the noise and Sunday reports supplied by the applicant. We are also concerned about the extraction of fumes if the plant room is allowed in its present location, having been built. If the committee choose to grant permission, there are concerns about the enforcement of the conditions which your officers recommend be attached to the permission. In particular, conditions 7, 10, 11, 13, 15, 16 and 17. These developers have a track record of doing what they like, an example of which, in the last few days, they have not protected the cedar tree at the front of the building from work on the parking and gardening area. Building materials are piled up touching the trunk. Recently, there was noisy work on site outside of permitted hours on 2 consecutive weekends. They failed to stop it and told the neighbours they could suck it up. They have a tendency to create a fait accompli and then ask for permission. This leads me to my final point, which is not exactly a planning issue, but a matter of principle. We feel that you should know that there is anger, and in some cases fury, that this developer has virtually finished the build contrary to present planning permission, and will get away with it if this application is successful. This is best summed up by a resident who did add roof windows without permission and tells us he had to remove them at his own expense. Also, another resident who said, next time I'm thinking of applying for planning permission, I won't bother, just build what I want. It appears to many residents that a two-tier planning system is evolved, and enforcement only applies to those with deep pockets. Thank you for listening.
Thank you for your time. Just before you go, committee, have we got any questions?
Yeah, sorry.
Mr. Pearsall, so thank you very much. Right, I have two objectors, Neil and Julie Huntington and Rosemary Fierce. Rosemary, you're here in person, yeah, and Neil online. You have 5 minutes between you. I hope you've sorted out how you're going to spend the time. Okay.
We are the immediate neighbours. During the last 15 years, we have had to respond to a bombardment of 17 major planning applications. In 2012, against the wishes of the then SODC Planning Committee, consent was secured for a large 2,000 square metre development. This would have a major effect on us, but we had to accept it. So it's hard to describe how disappointed we felt when we established the developers were knowingly not sticking to the approved scheme. In fact, on the very day we reported it, the developer was magically able to submit the fully detailed Section 73 application. We believe the office's report gives insufficient weight to the impact all the proposed changes will have on the immediate neighbours. No consideration has been given to the cumulative effect the amendments will have on what is already excessive. With regard to the gable end, in 2011, the Planning Inspector's report asked for greater separation between Eastfield Cottage and what was then Eastwood House. The owners and the planning officer agreed the hipped gabled end was required. The new owners bought the site 2 years ago, knowing this was the case, but then unilaterally decided to ignore the agreement by reducing this important separation. We agree that the Planning Inspector's report did not state that the appeal scheme is only acceptable with the full hipped end, but it is pure conjecture to state that he would have found the half hip acceptable. Please note, the gable end wall in the approved scheme would already have been 6.1 metres high and 13 metres across. What has actually been built is 8.2 metres high, 35% larger, increasing the scale from a domestic building to that of a 3-storey commercial building. The large plant room has been moved to a position only 11 metres from our bedrooms, from the original position on the second floor. The noise assessment confirms our bedroom would be subject to a 36 decibels at night. Yet the British standards limit, and that recommended by the World Health Organization, is 30 decibels. A quiet bedroom should be between 20 and 30 decibels. The report suggests conditions could be applied, but the applicant has so far shown scant regard to existing conditions within the planning consent granted. So how can we trust them to put adequate mitigation measures in place? Or indeed, is it even possible? Finally, we feel strongly that just because elements of the scheme have been built without planning consent, it should not be the justification for granting planning consent at this late stage. Thank you.
Yeah, you've got 3 minutes.
Thank you.
2 minutes.
Firstly, I'd like to thank those of you who were able to attend the site visit. It's very important that you were able to see for yourselves the oversized and overbearing nature of the development. I do not believe that the officers, in making their recommendations, have adequately considered the impact of these changes in a residential setting. Point 6.21 notes that under the amended scheme, the eaves and flank wall at 8.1 metres will be 2.1 metres taller. This is what we see from our homes, and it creates the bulk of a commercial building. The inspector, when determining the 2013 appeal, stated that a hip roof should be built, and I quote, "The impact upon the outlook from that neighbouring property, i.e. Eastwell Cottage, is further reduced by the substitution of a hitch rather than a gable end to the northeast elevation of the extension. The half hip
30 seconds left.
the half hip roof is not a neighbourly amendment and increases the impact of the build. If it was considered an acceptable solution, why was permission not sought before the build was undertaken? We continue to have concerns about the plant room referred to by the officers, noting that the company are installing external plant for which they do not have permissions and which could adversely affect neighbours. This is an organisation which is constantly seeing what they can get away with. As the planning authority, you must act firmly to ensure that proper safeguardings are in place."
Okay, thank you.
Thank you.
Right, Tracy, any questions for either of the speakers? I see not. But thank you very much. Thank you. Right, our final speaker is Miles Young, who's from Westbourne. Okay, please.
Thank you, Chairman. Members, thank you. We commend the report before you and the recommendation as now amended, and we thank your officers for their professionalism. My client, just to be clear, is both the developer and the operator of Cedar Lodge Care Home. They're here for the long term. They acquired the building in 2022, and they were aware of its complexities, particularly how a building designed in 2010 and approved in 2013 would now need to meet very much more stringent building regulations, fire regulations, and the Care Quality Commission's requirements, while still continuing to preserve the historic fabric of the building. Various amendments were required to achieve those objectives. Problems were insufficient space within rooms, compromised layouts, a lack of light and poor outlook for some of those rooms, insufficient space for the essential building services, boilers, pumps, flues, no clear strategy for landscaping, particularly the rear gardens, insufficient amenity and social space for the 45 residents of the approved rooms, no clear distinction between staff and resident spaces, insufficient storage to meet CQC standards, poor accessibility to the building, and, very important today, a lack of energy efficiency measures required under parts L and O of the building regulations. Each of the changes pursued by my client have been made not through aspiration or greed, but simply to ensure that each of the matters I just raised were adequately resolved, and to create a safe, efficient, and hospitable care home. As some of you saw on Monday, the proof is in the pudding. The changes are outwardly modest and fully supported by specialist officers of the council. Your officers have raised no objections regarding noise, outlook, daylight or sunlight, and some aspects you may see from the report have even been described as beneficial compared to the approved scheme. The residual matters are to be controlled through conditions. Our client has to date made various changes to the scheme to respond to local comments. They've proposed solutions to problems, agreed extensions of times, and submitted all of the justification sought of them. It's worth noting that whilst measures to safeguard the programme with the introduction of a comprehensive temporary roof structure to enclose the eastern side of the extension and allow for the roof alteration to be mothballed for a period of time in order to seek a planning resolution, but time got the better of us. As you're aware, the care home opens next month, and from construction to operational phase, we now see the crystallisation of the benefits. And I'd like to finish, members, if I could, just by focusing on a rather more strategic matter, by reading a passage from the Council's Joint Housing Needs Assessment, currently being discussed in your Joint Local Plan examination, paragraph 6.45, and it reads as follows. It is projected that an additional 764 residents will need bed spaces to be provided in residential or nursing care homes in South Oxfordshire over the period to 2041. The same assumptions have been used by Savills in their recent review of care homes in the district. They found that the rate of development of new care bed spaces is around only 30% of what is actually required to meet the needs of the district. Resolving that difficult problem must surely start with bringing vacant care homes back into use and maximising them where that's possible. And that is precisely what my client has done. Thank you.
Thank you. Right, committee questions for committees. I noticed Councillor Saddles on first.
Yes, so there seems to be a history of refusals on this site. Then there's the the P23 application, which was approved after appeal. And I think what I need to understand is why has your client chosen to go through variation after, make the changes and then apply for variation? So let me refer specifically to glazed windows that with it said in the condition 11 that these should be fixed shut and permanently thereafter. But obviously you want to vary that condition now. But that's sort of after the fact. You've already kind of gone ahead with these two dormer windows and so forth. So and that's massively overlooking Eastfield Lodge. No, I think it's Eastfield Lodge. I think it's massively overlooking that. So can you just explain how you got there? How you got to that point where you're changing these variations and then seeking permission for it afterwards?
Yes, sorry, Councillor, I think the first point to raise is I'm not sure your office has described any part of the report as massively overlooking, but park that for a moment. It was a difficult site from day one. They were well aware of that. And this application was submitted to the council in August last year. Absolutely no criticism of the council whatsoever in terms of the time it has taken, because we've had to amend the application on a number of occasions to take account of matters that have been raised locally. So that's why the period has stretched out, whilst constantly under pressure to deliver on site. So the application was in a long time ago, in the knowledge that changes needed to be made. You referred to 2013. That was when the appeal was granted and planning permission granted for the extension to the care home. Nothing to do with my client. My client acquired the site in late 2022, as one of the earlier speakers confirmed. And the past is the past in that regard. They've taken a very difficult permission and tried to bring it forward to meet all of the standards that have changed since that time. So building regulations, fire regulations particularly, but also the ever-changing requirements of the CQC, who we need to acquire registration from.
Councillor Gordon-Creed.
Thank you, Chair. I really appreciated hearing your side of the story with regards to the regulations that you had to adhere to. And I think it would help me to hear very specifically how and if those apply to the change from the half hip to the hip to the half hip. I assume there's a reason. I'd really like to hear it if you can.
Yeah, thank you. It's a very good question, because it's one of the key issues here today. One of the most fundamental issues that my client faced was a dearth of space for all of the things that make a building like this work. So boilers, air conditioning, flues, internal comms. There was so little space within the 2013 appeal scheme to achieve those things, and that's why various changes had to be made. And there was a complete reorganisation of the interior of the building to deliver space required for 45 beds and space required for staff and communal facilities, whilst also making sure that building services were delivered. And there were two ways that was achieved. First was to relocate the laundry to the space in the half hip, and there was no way that the things were going to fit into that space without change, but also to install a sort of semi-basement undercroft, as we're calling it, to the terrace area to install more the back of house services. The thing to be very clear about is those are all internal facilities. But yes, it was driven at the needs of the building in order to be a modern, safe, effective, welcoming building.
So very specifically, the laundry area is now in that space, and it wouldn't have fitted otherwise.
There was nowhere else to, yeah. And we've struggled even now, and it's quite I'm also saying it's a miracle that they've managed to squeeze what they have into the building to make those 45 approved beds work under today's regulations.
Councillor Topping.
You said that the changes that you've made now are based on the fact that a lot's moved on since 2012, 2013. And having worked with care home developers in a past life, I accept that regulations do move forward quite rapidly. But what surprises me is that after 3 refusals, looking at the planning history, there was an approval, albeit an appeal, in 2024. So what's happened? Why the change since then? Why did you have to revisit what you got planning permission for less than just over a year ago? What's changed in the last year?
Yeah, can I make a point of clarification? You mentioned an appeal in 2024. I'm not aware of that.
I'm just looking at the P23 S73 approval.
2013, the appeal. Yes.
There was an appeal in 2013.
There was an approval of conditions, change of conditions in February 2024.
That, councillor, was to make some very minor changes to landscape layouts and tree protection.
Okay, so having got that approved, why didn't you tackle it all at the same time? Why then go through the process, build it and make changes whilst you're building, rather than making a comprehensive application to make all the changes at that time?
Yeah,
this is salami slicing from what I can see.
So obviously delivering a difficult building pursuant to very old consent in challenging locations is never straightforward.
Yeah.
I've never seen in 25 years a single planning permission for a care home in a difficult site delivered on it exactly to how the plans show, because planning is very different to building regulations and detailed design processes. So some aspects were sort of rather imposed upon us by the regulations that were required, and architectural gymnastics were carried out inside the building to make it fit for CQC approval. But we took on that challenge, and I dare say that any other care home developer would have faced exactly the same problems.
Any further questions? See none. So thank you very much, Mr. Young. Peter, do you want to speak as a councillor or speak? Okay. Councillor Dragonetti, you will speak as the ward councillor, which means written question.
Yes, this is a difficult application, isn't it? I just turn to well, there are lots of issues here, but the one that's real the important one is this question of the impact on Eastfield Cottage, the neighbour, where there was supposed to be a hip, and there's now half hip. A half hip means it's a half gable. As we saw on the site visit, extensive area of brickwork, very plain brickwork actually. I would have thought that if you're going to do brickwork, you'd actually made it slightly more interesting, but there we are. And I refer to our original planning refusal of planning permission back in 2011, where this council refused it because the proposed development, due to its siting, design, size, bulk, height, and massing, have an overbearing effect that cause overlooking to the neighbouring properties, most notably Tanglewood to the west and Eastfield Cottage to the east. So back in 2011, 14 years ago, we knew there was a problem there with affecting Eastfield Cottage, and the planning inspector picked up on that as well. So in his decision, when he considered the appeal against that refusal of planning permission, he noted that Eastfield Cottage would be impacted by this development. But he did say that the impact on the outlook would be reduced by the substitution of a hips rather than a gable end to the northeast elevation. So our officers knew it was a problem, planning inspector knew it was a problem, and they came up with a solution, which was a hipped roof, which means that instead of having a large extent of plain brickwork, it's the extension of the area of plain brickwork is less, so there's less dominant, and the roof line is set back because the ridge line is back, and then there's the whole thing provides less overbearingness to the residents of that house. Now, it's very curious, isn't it, that these two, our own officers and the planning inspector noted that the impact of this development on Eastfield Cottage, and yet this developer and operator of care homes, lots of experience, knows lots about building, I'm sure, knows lots about building care homes, difficult sites, but they ignored this judgment of the planning inspector. And they took a risk. Now that's fine, they're entitled to do it, and retrospective applications are perfectly lawful, and we shouldn't be penalising the applicant for that. But what we should be looking at is just considering what the impact is of Eastfield Cottage, that neighbour, of this development. In a conservation area, it's the largest building in the village, has a very significant effect, and it has an adverse effect on the amenity of our residents. This half hip rather than a full hip has an adverse impact on the neighbours immediately adjoining this development. So I would urge our member of the committee to think carefully about what this developer has done and reject this application.
Sorry. You could now ask you questions. So, Christine.
Yeah, just one specific question. Is the ridge height higher, lower, or the same?
In respect of this,
when the hip goes up to the ridge, is the ridge higher, lower, or the same as the drawing?
I couldn't say.
We've seen the drawings.
Well, yeah, but
You attended the site visit.
I did, but what matters is the impact on.
I didn't ask you that. I just asked one question. I asked you the ridge height. I didn't ask you any other question. That was the one question I asked.
I'm afraid I can't answer.
I answer for it. It's the same.
Thank you.
Any further questions? No. Oh, Councillor
Well, only that if this were to be refused, this new roof design has now been built. Would that mean that they would have to?
I think that's more a question for the officers rather than for the member.
Demolished.
Axel, do you have a question?
That's all right, you answered. I'll go for it.
Yep, Councillor.
Yes, Councillor. I just wonder how you feel about these dormer windows that face out over East Road.
Well, to be perfectly honest, although some of my residents, my ward may think otherwise, I would let those go, because the residents who are affected are some good distance away, and I don't think, in all honesty, they'll have a serious impact. And if it wasn't for this gable on the closest house, I would, this wouldn't be significant.
Okay. Thank you, Councillor Dragonetti. Okay, we're going now to questions back to Sarah. Can I ask one which is on condition 11, which was raised? Could you just explain condition 11? Which is windows on the first and second floor room. Yeah.
Yes. So that condition was applied to the original 2013 permission, and it's just updated to pick up a requirement for the additional window in the northeast, the additional dormer in the northeast corner to be obscure glaze, as well as the.
Can we see which one those are?
Of course.
I can't do my northeast and west, but without a plan in front of me. Could I ask Neil and Julie Hunting to turn their camera off, please?
Thinking about changing the slide.
That's gone. Right, I can't read that.
Let's go back to the plan. Let's just. Side to windows in first and second floor levels in the west side elevation. So that was windows in this elevation. And because there's this additional dormer window here as part of the changes, the wording is amended just to require that window is obscure glazed and fixed shut as well, to prevent overlooking of the neighbour to the north.
The fully right one.
Yes.
Yeah.
Yeah.
Okay.
Yeah.
That's the laundry window.
Yes.
On conditions. Is that forcible? Because I'm just thinking it's built, it's there, and then 2 years down the line, the next year's appeared, but by then everyone's forgotten about, well, maybe not the neighbours, but they've forgotten about it. Just a question.
No, absolutely. I think these various conditions that sort of relate to potential enforcement matters have been discussed with colleagues in enforcement, who are the ones who will actually have to, practically take enforcement action. And as you acknowledge it, it's not something we could closely monitor as officers. It would rely on it being reported to us by neighbours, but colleagues who are in enforcement are comfortable that is something that they could enforce.
Okay, thank you.
Okay, Councillor Sadler.
I've got a few points for clarification on the report.
Yes.
Thank you for the report, by the way. It's really detailed and massively complicated, so I do appreciate that. On page 13, 6.8, it refers to rear extension not being visible from public view. When I visited the site, and it bears it out from the pictures, it's quite dominating. Actually, it's more than visible from the front. It's actually bigger.
I think what I meant by that is that the change, obviously the extension as a whole that's already been approved under the appeal is very much visible from the public realm. This change to the roof is not so prominently visible from the public realm. The change from the hip to the heart pit. Yes. Yeah.
Okay. And 6.20, issues over boundary.
Yes.
Civil matter, and I know a lot of the comments from residents, they feel that actually the boundary issue, although it is a civil matter, it's very relevant to some of the things they're talking about. And unfortunately, I didn't go to the site visit, so I couldn't. So I don't have the. I don't know what the issue was with 14 Swanston, but I think there was an issue there about the boundary and the window relative to the boundary and the corner of the building. Could you just speak
Yeah,
through
of course. So I think there's potentially two slightly separate issues. Some of the comments that have been made by that neighbour relate to concerns about overlooking of their garden from the ground floor element of the extension. So that's this part here, which is what was allowed at appeal and is not changed as part of this scheme. So as you acknowledge, even if that issue of the boundary is a civil matter, we obviously need to be satisfied that we can appraise the relationship between the development and any neighbouring properties, and that there's sort of good enough information about where the boundary sits in order to do that. But in the case of this ground floor element, no changes to that are proposed as part of this application. So that's a sort of separate issue outside of this application. What is relevant in the case of the changes that are being considered is this additional dormer window on this northeastern corner. And so obviously if the boundary was significantly in the wrong place, you know, it would be possible to say, oh, the dormer's actually further away from the garden than it's shown on the plans. But I think, I can't remember exactly where it's set out in the report, but that's a very long garden, that property to the north. It's about 75 metres long. And while there would potentially be some overlooking of that very bottom part of the garden, sort of irrespective of where the boundary sits precisely, based on the length of the garden, it would be the very bottom of the garden that would be slightly overlooked, and the condition is worded to require that window to be obscure glazed and fixed shut. So any perception of overlooking would only be localised in that very bottom part of the garden, and they would retain an extensive area of garden that would not suffer from any perception of overlooking. That answer your...
Could I add a little bit to that?
Of course.
It was one of the concerns I had when we went on the site visit, was that particular vision, that particular aspect. Yes, that garden is very long. And in that particular corner, there appears to be a home office sat in the corner of the garden. So you can't actually get to the bottom of the garden because there's a home office sat there. Yeah, plus the vegetation. Yeah. So I did have a concern when I went. I didn't have a concern when I left. Yeah.
Another one?
Yeah. So we need to clarify all the points really.
So page 24, 6.61. Resident suggested enforcement action suggests matters can be regularised through retrospective and in the normal way, which then in turn refers to the number of times being subject to planning enforcement. So you kind of that's kind of going around in circles a little bit, isn't it? So you go to enforcement, try and get a stop notice put on these people, but actually if enforcement then just goes, yeah, what you need to do is just go and put a retrospective in an S73, then and then if you break that, it's back to enforcement.
Yeah.
Are they just going to keep saying, yeah, just put an S73?
I was going to ask our head of planning to comment on that in a few minutes.
Okay.
Can we leave it with that, because it was raised the lack of enforcement and don't believe enforcement's being carried out. And
Chair, it's a common problem.
It's a common problem. Yeah, that's why I wanted our head of planning to comment on that. Do you want to do it now?
Yeah.
Or can I just ask Sarah a question?
Yes, of course.
Yeah, the noise level was raised.
Yeah.
Yeah. And I can't find it in the report because the speaker said it was above what it should be, or the report said it's going to be above what it could be.
Yeah.
Yeah.
So I think that's a useful point to clarify, because as part of the application, 2 separate noise reports were submitted. The first had assessed the background noise level at the closest noise sensitive premises to be 32 decibels, and then the subsequent assessment assessed it to be 36. The condition, as it's worded, requires that the noise from any plant is 5 decibels below the background noise level. And having discussed it with the environmental health officer, he's of the view that the first noise report that assessed it to be 30, the background noise level to be 32 decibels, is a more appropriate level to use for the background noise level. So then the condition that requires the noise from plant to be 5 decibels below that would be 27 decibels, and the speaker referred to the World Health Organization requirement for it to be, or recommendation for it to be 30. So in effect, the condition would require it to be below 30.
Okay, yeah, I was having a short discussion on the way in about noise, and you mentioned it. It's not particularly an issue for us to enforce. It's an environmental health issue. Yeah. So it's for them to enforce, not for the planning.
It's both. We're able,
Okay.
yeah, we're able to.
It's a grey area.
Yes, we're able to, through conditions, apply, limits to noise and that kind of thing. But then, as you say, there is separate nuisance legislation that environmental health are also able to use to enforce against.
So you're the condition sets the noise level less than the legal requirements are, and it's considerably less.
Yes. Yeah.
Okay.
Yeah.
That's really relevant. Right, we're still on questions to Sarah, and I'll go into Adrian to talk.
Okay.
But
Thank you, Chair.
Yeah.
So
Go on,
I
Chris.
just wanted a little bit of clarification to do with
that
the
context.
external installation of plant, basically flues and noise and all that, as being something that's not allowed without, this doesn't cover any of that. And has any of it been done already is my question.
Yes.
So therefore, the requirement, as I understand from this, is it needs to be removed.
So there's,
Is
Yeah.
that true? Yeah. I
Yeah.
just wanted that.
yeah. So I think
And enforcement is on that, is my next question.
We'll go back to enforcement. Yes.
So yeah, the details, while some of it has been installed, the details aren't provided as part of this application. So we're not considering, whether to approve them as part of this application. But as you acknowledge, conditions 17 and 18 relate to that plant that has been installed. So 18 requires it to be removed unless satisfactory details have been approved under condition 17. So there's a possible scenario that they submit details under condition of what has been installed, and that's acceptable, which then sort of satisfies condition 18 and it doesn't have to be removed. And then to come on to your question about enforcement, again, these conditions have been discussed with enforcement colleagues, and I think I'll obviously let Adrian come on to talking about enforcement kind of more generally, but I think there's generally, if a breach of planning control can be regularised through a planning application, that's often a preferable route and ultimately ends in the same outcome as taking formal enforcement action. And in this case, while there's been a live planning application, we've sought to sort of resolve those issues through the application. But in the case of this external plant, that's not part of the application, and enforcement are sort of fully poised and prepared to take necessary action once a decision is issued, if necessary.
Okay, right. Now I've got a question from Councillor Topping. Then I'll come back to you.
Partly a question, partly an observation. A lot of things can be dealt with by condition, overlooking, having obscured glazing and windows that don't open. Noise issues can be dealt with, again, reasonably well by condition. But the one thing that cannot be dealt with by condition is this hipped and half-hipped situation. This is something that would require a physical change, a significant physical change.
Is this a question for
to the bill? Yes, it is. It's how, if we were to say no to this application, how would that be dealt with? Question. Yeah.
I think typically what would happen, it would depend on whether that decision to refuse the application was appealed or not. I think if it was appealed, again, having spoken to enforcement and they're aware of what my recommendation is, they're sort of provisionally of the view that if there was an appeal progressing, they would likely hold off formal enforcement action until the outcome of that appeal was known.
Yeah.
And obviously then, if the appeal was allowed, they wouldn't need to take any action. If the appeal was dismissed, at that point, they would then need to go down the route of formal enforcement action, which ultimately could require, the changes to the roof to revert back to the approved scheme. That's the sort of ultimate possible
But if in
outcome.
the meantime, I think I heard the plan consultant say that the property is going to be occupied in a month's time.
That's their plan.
That's their plan.
Can I go to Councillor Higgin?
Yeah, mine was just on external plant still. So there's plant there which doesn't have permission. There's a condition to remove it. Presumably that plant sounds like it's there because it's needed to be there for the operation in a month or two's time. So air conditioning, which the gentleman who spoke to sport specifically mentioned being required. Is it normal at this stage in the process to not have that application in?
I don't think anything's normal in this case.
Yeah. I suppose as an observation, if there was a retrospective application and plant was obviously needed, does functioning of the premises, would you not expect it to be included in that?
I think one of the answers to that is the planning consultant is sat listening. And he's going to go away and take notice of what's being said.
Yeah,
I hope. Yes,
And
he's nodding.
If I might just come in just to say, I think as you know, the sort of decision maker, we need to make a decision based on the application as it's submitted, and it's possibly slightly unusual to apply conditions that relate to things that aren't part of the application, but in this case we felt because of the potential risk of there being an impact on the amenity of neighbours, it was appropriate to apply those conditions, even though, you know, the external plant doesn't actually form part of the application because it's already been installed.
Thank you, I appreciate that. So logically speaking, it could well be that another application is in the post vis-a-vis that external plant.
Yes, I've already been informed by the planning agent that they are preparing the submission of a discharge of condition application, and the information that would be needed were this to be approved to then submit to satisfy those conditions.
Yeah. Okay. All right. I'm going to let Adrian have his 5 minutes.
I think, to be fair, Sarah's a quite a helpful explanation. But in terms of, as Sarah explained, in terms of the situation on enforcement, we obviously take the approach which is a national guidance. It's set out in the NPPF that actually we should seek to resolve the matter first of all. Enforcement action, informal action, is a last resort. So that's where we are here in terms of. We said to the applicant there's potential to make an application. We've done that, considered that. You are considering that tonight as a committee. Whatever the outcome of that is, if you are minded to go down the refusal, let's say, and they then appeal that, and then, as Sarah talked about, we will see the outcome of that. We could then serve an enforcement notice. Of course, they can appeal an enforcement notice. So the process goes on, and I'm afraid that is how the planning system works. It does take a long time. Now, potentially you could serve the enforcement notice at the same time in terms of a decision on the outcome of the refusal, and the two could be done in parallel. But the issue would be about expediency. We'd have to look at that as an independent assessment at the time. But yes, I mean, we set out the approach in our enforcement statement, which I'm sure you're aware of. We've done training on that. And that follows the national practice and follows the national planning policy framework as well. I hope that just gives you. It may be frustrating to understand for the community, for you as members, but that is
it keeps coming up, and that from outside, from the public's point of view, they don't have sight of the enforcement going on. No, because it's not been done in the public, so they think nothing's happening.
Yeah, definitely.
But so that may be down to the council to actually give that a bit more publicity, but that is the fact. Enforcement is going on.
Yeah, correct.
And quite correctly, but yeah, we don't always know it. Okay, I think we've questioned it as you've got a question.
I've got one question. Yes. So presumably, normally, you know, sort of as planning officers, you work so closely with developers to help them achieve, you know, development that is acceptable and sustainable and everything like that, and you try and get to come out with the best solution. In this case, the residents became aware, I think, of work that wasn't being done according to the plan. Some time ago, when the scuffling was up and the bricklayers were there, and presumably you got onto the developers then and sort of had a discussion with them, suggesting that they would what they were doing wasn't going to be acceptable as it stood. What response did you get from them
I wasn't involved until the point at which the application was submitted. So I think,
but that's enforcement.
yes, yeah.
You
So
only got involved with the application came.
yeah,
Right.
yeah.
Enforcement are not here and not responsible to us. I think we've
So can I just ask one more question?
one more question.
And can I ask Adrian? Because Councillor Dragonetti makes a very good point there. I mean, there's periods of time where something was going on, residents were informing enforcement. I mean, surely an injunction, I mean, just, you know, from an outsider's point of view, which I feel I still am, I'm not the council, from my perspective, you know, surely you can put a stop works on that. And that's the simplest way of all, before they get to the point where they're, yeah, it's built already, and now can we just go for a variation of
I mean, you are the council. You're a member of the council, so you are the council.
I'm an elected representative.
Indeed.
Elected representative.
So in terms of that situation, as I said, the national advice, our advice on enforcement statement that follows the national advice is you don't go down the formal action straight away. It has to be, you know, in terms of it's a listed building, for example, and they're destroying the listed building, then that's where something like a stop notice or injunction may be appropriate. In this situation, where there's a potential for an application to be made, to be considered as it's before you today, then that's the approach that the government recommend, and that's what we're following, that best practice.
Okay. All right, thank you. Right then, committee, we are at the stage now where we need to debate this. Yeah, and I need a motion. Councillor Arlott.
Yes, Chairman, I'm going to propose officer's recommendation, and if I get a second, then I'll tell you why.
Yeah, okay, is that seconded? I will second that. If it's not, I will second that.
Okay.
Can I just stick a minute? Do we need to have a quick discussion around potential predetermination and what happened?
Yeah. I was, yes. Where you mean from Councillor Dragonetti?
Mm-hmm.
Yeah, I think
I'm not going to vote.
He's not going to vote.
Okay, that solves it. Thank you very much.
Yeah. If I hadn't have gone on the site visit, I would have asked the same questions that you have over there. I think it's the longest site visit I've ever been on one particular application. We were there for over 2 hours. Visited at least 4 properties. We looked from all different angles, and then we had a guided tour of the care home. I can understand exactly why they've done the raised the wall on the gable. Once you got into the property, if they hadn't have raised the hip up till there, you wouldn't have been able to get 2 or 3 rooms in there. I think the agent kind of mentioned that. There are basically 3 issues. There's this gable wall, which obviously has been removed, but the extra 3 dormers and possibly overlooking. But saying that again, there were a number of the houses we went into. You could almost say that they were overlooking the application site as well. The gable, the extra gable, I agree. You can see that, but then again, at the end of the day, you would have seen the hip roof as well. You know, all you're seeing, rather than seeing a hip roof, you're looking at a gable, which is probably over a metre higher than the proposal was. The 3 dormers, yeah, well, one could consider, you know, you'd be overlooking the other properties, but there are a number of dormers there anyway, which were doing similar, and obviously there again they put these dormers in there for a simple reason, to obviously make the rooms bigger. You know, the care home rooms have to be a specific size, and these weren't, and that's why they put the dormers in there to give them more rooms there. So yes, it has added 3 dormers, but at the same time there are a number of dormers there which we're doing exactly the same thing as these 3 new ones. So, you know, going on overlooking, I accept there is a certain amount of overlooking, but the majority is overlooking, you know, large back gardens. There was the one about which was mentioned, a complaint overlooking. And we went into that room, and to be honest, you couldn't see anything. Maybe you were overlooking a long garden, but other than that, you were looking at anything else. We're in a poor position. We're in a really poor position because we lost an appeal. And for these 3 items alone to go, if we were to refuse this, dare I say, I think we would get slaughtered on appeal again. Would I have voted for it in the first place? No, I wouldn't have done. But we're in this situation now where, as I say, we've lost the appeal and we have to move on from there. So our previous decisions, the previous reasons for refusal, we can't use those again because that would go against the inspector's report. So I say, if I hadn't have gone to the site visit, I would have probably voted against it. But the longer we were there, and the more that I looked at it, and it is a big building. I totally accept it is a big building, but then there are some big houses around there as well on large plots of land. And we are where we are, and I really can't see any reason at all why we should even consider rejecting this application. There's 18 reasons for conditions there, and providing we stick to the conditions and we make sure that we stick to the conditions, this should cover numerous people that have objected. I think the owner the agent for the property that owned the building, we had a good chat with him, a good guided tour with him, and I totally understand why they had to change some of the outside to make the rooms bigger, which I've obviously said that before. So as much as I would have probably, as I say, I would probably look forward for refusal having not be there, I really can't see any specific reasons why we can refuse this application. Thank you.
Thank you, Councillor Rollins. Does anybody else wish to speak? Councillor Sadler.
Yeah, I think Eastfield House, obviously the lodge that is now known, was originally an extensive dwelling with substantial grounds, and over the years the grounds were sold off to accommodate housing. So in the 1980s, Eastfield was already a care home with minor alterations to the rear. If you look at Google Maps, you can see the Google Maps now shows what that extension used to look like. Yes, it crept quite a long way back, but it didn't have that sort of very imposing facade. And it really, it is very overbearing to its neighbours, to Eastfield Cottage. Eastfield Lodge particularly, it's interesting how people feel that that's not affected, but I feel that's probably the most affected, in my opinion, and Eastfield Cottage. There's been a whole raft of proposed changes over the years, and the council has clearly not been happy with those changes, and has sought over time by varying conditions to try and sort of stop the flow of all these changes. But I think what's happened now is we're now in a situation where condition 11 has changed, condition 4 has changed, and so on. And it just goes on like that. I really kind of feel for reading the residents' comments. I really feel for them, because I think they're saying a lot of the things that are quite obvious. I didn't go on the official site visit, but I did go down over the weekend and have a look from the street, and I could see for myself. It was a very imposing building at the back. And by the way, the site's very untidy, and there's a skip on the road, and the verges are damaged, and so forth. This is a major change to what was once probably a lovely country house in the middle of nowhere, and it had lots of grounds around it. Had they been proposing this kind of change to the existing property without all the other Eastfield residents, I probably wouldn't be overly concerned. I think the needs of the developer to get rooms into the building is irrelevant. It's about what impact it has on the conservation area, on Whitchurch, on the residents who can't do anything about the situation. They're already, they have their house, they have their life's work around them. And it's up to us as elected members to protect people against developers coming along and just doing what the hell they like. And the fact that they've gone ahead and made changes which may have been accepted or may not have been accepted, we don't know. But to actually go ahead and do that without seeking the proper planning permission, to me sends a very sends the wrong message. And I think they are the conditions, and those are the conditions they're trying to vary. So what? So what? We're going to give them more conditions, and then what? Vary those? I mean, I don't know. Where does it end? I think we probably should really refuse Section 73.
Anybody else wish to comment? Councillor Topping?
Yeah, I find this very difficult. I wasn't able to make the site visit. I think site visits are massively important to really understand what's going on. This is very difficult. I agree a lot with what Ed Sadler's just said. It's very upsetting when these after the event applications come in and make changes that are having significant effects on the neighbouring properties. On the other hand, this is a building which I understand from the report has been empty since 2016. It is a heritage building which presumably would be deteriorating if they hadn't have done the investment that they have now made. And when it opens, it will provide good modern accommodation for elderly people in a situation where, with the ageing population, we need more such accommodation. It'll also provide jobs. So there are upsides to this permission being given. It would also draw a line under a saga that's been going on for, I think somebody said, 15 years. But it's very upsetting and irritating that we are put in this position of gun at the head. It's a very, very difficult decision, which is why after an hour and 20 minutes, we're still talking about it. This is, I mean, I've only been on the committee. This is now my fourth or fifth committee. This is by far the most difficult thing that we've had to decide. And I'm not sure where I want to go on this. I'm still not sure.
Councillor Gordon-Green.
Well, having just been on the receiving end of the updated requirements from central government with regards to planning, I find this incredibly painful as well. I totally agree with Councillor Sadler that the justification of trying to fit 45 rooms and change the HIP, if they'd gone for a lower number of rooms, possibly could they have done the right thing with regards to what permission was ever there? We don't know. And it makes me deeply sad and demoralised, I guess, that developers on the whole just do that. But on the other hand, we have not got a leg to stand on when it goes to appeal. We will lose an appeal. And the central government mandate at the moment is, well, and also the housing needs. We need those homes. And the cost to the council to go to appeal, just to go to appeal, could be £100,000, which is out of the community. The government is then likely to award costs against us because of going to appeal in the first place. So it's a horrible situation. And I so feel, the letters that the residents wrote, it shouldn't have had to be written. I'm very minded of where we are in terms of law. I just want you to know I wish I wasn't.
Yeah, I did second it, so I was speaker's seconder. Yeah, I agree with everybody. It's not an easy one. But I must point out, we're not talking about the care home. The care home is there and that has got planning permission. We're talking about the small amendments to the care home. Yeah, we're not talking about the care home itself. Yeah. and I did go on the site visits and looked at it from every angle. And yes, it is a large building which is showing there. But does that hip roof make a great deal of difference? I don't think it does. It's still a large building which is dominating, but that's what's already there. Yeah, it's a bit of the hip that we're talking about. It's still there. It's still dominating. The dormers, I don't think are anything. They're spread out. They're nicely levelled, and the undercroft, yeah, it's there, and it seems to make sense to put it there. Did they do the right thing in not applying for planning permission before they did it? That's not for us to judge. It really isn't. We don't like retrospective planning applications, but those are what come in, and we went through the training on Monday night, and it said you deal with it as you do with any other application. You don't penalise them for being retrospective. And so, yes, I've seconded it and I will support it. Is there any other comment? I'll go back to Ken to sum up. Will you sum up, Ken?
Yeah, no, I'd just like to pick up 2 or 3 points from Councillor Sadler. But I'm sure we all feel about the objectives, but anybody that attended planning training on Monday evening would realise that unfortunately they aren't reasons for refusal. We're going to look for reasons, look for reasons. The changes, they are there. We accept that, the 3 dormers and the gable wall. But in the big schemes of things, I would suggest they are minimal, personally. You mentioned about the impact on the conservation area. Without the gable wall, without the 3 dormers, you've got the same size building. So you've still got the impact there, which has got planning permission. So to say there's an impact on the conservation area, obviously that doesn't help see. The hip where they've made the new rooms, there are no extra bedrooms in there. They're the washing room and just other small general rooms. They are not extra bedrooms. As much as I would like to, and I probably would have done when this first came to committee, I would have probably objected to it. But I cannot see what there is there now and what was passed on their plans by the inspector. I don't think there's sufficient anywhere near to refuse this application, and that's my view. And yeah, I so much.
Thank you. So we have a proposed and seconded for officer's recommendation for approval. All those in favour?
With the condition.
Oh, with the amended condition, sorry, which we've just been told not changed. Yeah. All right. All those in favour, please show. 1, 2, 3, 4, 5. 1, 2, 3, 4. That's 5, 4 against. 1 abstention. 2. So that is passed. Thank you, Sarah. Right, that's taken an hour and 20 minutes. I'm going to suggest to take a short break. Yeah.
I remember some discussion.
Yeah, I just remember. And then we'll move on to the next agenda item, which is P24 S2309 form, which is land to the northwest of Pangbourne Technical Centre. And the planning officer is Amanda Rendell.
Thank you, Chair. Good evening. This application seeks planning permission for the installation of ground-mounted photovoltaic solar panels for a period of 30 years to generate up to 2.5 megawatts of electrical power to be utilised by operations at Pangbourne Technology Centre. The site layout is shown in Appendix 2 and on the presentation slide.
Amanda, can you speak up a little
sure.
bit, because I can hardly hear you, and we don't have any microphones here, which is unfortunate. I can never go ahead of planning if not having microphones, but
Do you want me to start again?
no, just carry on. But just, I'm not sure that came to the end.
Sorry?
No.
Yeah, I'm fine.
That's all we can.
Yeah, that's still like
Sorry, I stopped you in full floor. It's got confused things now, hasn't it?
the mouse just jumped up. Yeah. This application seeks planning permission for installation of ground-mounted photovoltaic solar panels for a period of 30 years to generate up to 2.5 megawatts of electrical power to be utilised at operations at Pangbourne Technology Centre. The site layout is shown on Appendix 2 and on the presentation slide. The site is within the Pangbourne Technology Centre, which is a research centre for the development and testing of engine fuels and lubricants under the BP brand. The whole site is situated within the Chilterns National Landscape, and the site on which the panels are proposed is maintained grassland as part of the centre's wider curtilage, previously used as recreation space in connection with the technology centre. There are a number of residential properties situated around the site, along with mature trees protected by a tree preservation order. An operational and redundant MOD fuel line runs across the middle of the site. I'll carry on talking. The application proposes the erection of solar panels arranged on a racking structure approximately 1.1 metres above ground level, mounted at an angle of 10 degrees. Plant compound comprising inverter, transformer, switchgear and enclosures to the battery energy storage system is also proposed to be sited on the eastern part of the site. The report explains that there's a strong national and international agenda to reduce CO2 emissions through the generation of energy from renewable sources. The NPPF indicates that when determining applications for renewable and low carbon development, local planning authorities should not require applicants to demonstrate the overall need for renewable or low carbon energy and give significant weight to the benefits associated with a renewable and low carbon energy generation and the proposer's contribution to a net zero future, recognising that small scale and community led projects provide a valuable contribution to cutting greenhouse gas emissions. Members will be aware that permission has recently been granted on appeal for a much larger solar scheme at Denchworth, which was a 30 megawatt scheme over 62 hectares, and at Burcott, which was 49.9 megawatts over 56.7 hectares. A small solar scheme of 1.4 megawatts over 2.4 hectares was also approved in December 2022 at Icknield Farm in Ipston, which is also in the national landscape and was similar in that it served the adjacent anaerobic digestion plant. Proposed development has been assessed in terms of its impact on the national landscape. In accordance with the NPPF, it's considered that exceptional circumstances apply when taking into account the need for the development.
alternative options and any detrimental impact on the environment. In terms of need, the solar panels would provide clean renewable energy directly to the technology centre. There is no proposed connection to the grid. This would reduce the current demands on the grid from the centre. Alternative sites within the technology centre have been assessed, all of which have constraints, and it was concluded that this was the most suitable for development. The submission of further mitigation planting and landscaping information has now addressed concerns raised by the Council's landscape officer, and no technical objections are raised, subject to conditions regarding a detailed landscaping scheme and landscape management plan. The impact of the development of heritage assets has also been fully considered in consultation with the Council's heritage officer and Historic England in respect of the adjacent listed building, Thatch Cottage, and Bowesdown Camp scheduled ancient monument, further to the east. Further mitigation planting has also addressed previous concerns raised by the Council's heritage officer, as these now introduce a denser band of intervening planting to better screen the compound. With regard to ecology, the Council's ecologist has not raised any objections. A separate condition regarding biodiversity net gain will automatically be applied under Section 7A of the Town and Country Planning Act 1990. No objections are raised in respect of glint and glare, trees, access and parking, archaeology or flooding and drainage matters. Whilst concern has been expressed by local residents in respect of fire safety and radiation, the application is accompanied by a fire safety statement and no objections have been raised from Oxfordshire Fire and Rescue. All electric equipment to be used in the development meets the European Union's Electromagnetic Compatibility Directive and are CE marked. The applicant has agreed the planning conditions are set out in Appendix 10, subject to the rewording of Condition 3, which has been amended to remove reference to commercial export. This is a standard condition that we use on solar schemes that are providing electricity to the grid. As this development will only serve the technology centre, this has been replaced with first export of energy to Pangbourne Technology Centre. For these reasons, it's therefore recommended that the application is approved subject to conditions and the legal agreement securing the implementation of a habitat management and monitoring plan for 30 years.
Okay, thank you, Amanda. Okay, I have again a number of speakers. Two parish councils, Mr. Elizabeth Cole, I said it from Goring Heath Parish Council, and Dana Smith from Whitchurch on 10th Parish Council. Would you both go to the table, please? You've got 5 minutes between you.
Right. Now, this statement is actually prepared by another councillor on Whitchurch Parish Council who wasn't able to be here today. So I think questions should be directed to this councillor who's.
I can only allow the person
I
to
will read
speak
it out.
and ask questions with the person who's ready to speak.
I'm just saying.
Have you got Elizabeth Colas? Is Elizabeth Colas with you?
Yes.
Yeah.
Whitchurch Parish Council objects to this development, giving its inappropriate position in an area of natural beauty and the fact that crucial flaws in these proposals remain unaddressed. SODC's ecology officer stated that there would be damage to the grassland habitat underneath and potential harm to local species. These points have not been addressed. SODC's landscape officer has also made comments that the mitigation proposals are inadequate and the applicant should consider moving the solar panels to an alternative location to existing development. These points remain unaddressed. We support local neighbours who've raised concerns that the glint and glare report does not adequately take into account the impact to first floor windows. This point has not been addressed. We also know that the visible assessment did not take account of the impact on Old Lodge, the closest dwelling, nor the increased visibility in winter. Again, these points were raised and not addressed. This is agricultural land within the AONB, and this status should be protected. The fact we are in the AONB means that the views of the ecology and landscape officers should carry even more weight rather than be ignored. Whilst we understand the need for renewable energy sources, we strongly urge the committee to listen to some of its own officers and residents in asking the applicant to move this proposal to another area of its vast site where there will be minimal impact to the environment and local residents. It seems entirely contradictory that SODC would allow an application for solar panels to be approved that causes damage to the natural landscape and habitat when the applicant owns large adjacent areas of tarmac developed land which could house these panels and avoid damaging part of the AOB. Thank you.
Yes.
Yep, good evening. My name is Elizabeth Collis. I'm the chair of the Goring Heath Parish Council, which this site sits within, and just slightly bordering on the neighbours. Goring Heath Parish Council have objected to this application's development, and our original objection was several objections, but I feel there's one very overriding and most important objection, and that is to do with the national landscape which sits within. And as such, it should be afforded very high protection from development. The National Planning Policy Framework, paragraph 190, sets out very clearly that permission should be refused for major developments within a national landscape, except under exceptional circumstances. The proposed solar power arrays have been classed as a major development. The Technology Centre has been expanding within confines of the built-up site. The submission from the Technology Centre claims that it needs power for an increase of activity on the site. The increased demand is partly due to the recent addition of a battery testing centre. Presumably, the need for extra power was known about at that stage. It is disingenuous to claim that this is an exceptional circumstance and in no way can be seen as justification for going against the policy, the NPPF. If the site cannot access enough power from the existing grid supply, then the problem could be solved by relocation of the facility to a more suitable site. The fundamental issue of whether major developments should be allowed in the national landscapes on lands currently not developed and not allocated for development within the local plan is at stake here. This issue is being obscured by the extensive references in the application to planting mitigations in the form of hedges and trees. These merely divert attention from the main issue and could be read as a sophisticated form of greenwashing. Thank you.
Okay, thank you. Commissioner, are there any questions? Yeah.
Do you want to ask your question? Sorry.
Yeah. So I just wonder, do you feel that?
Sorry, could you speak up, please?
Sorry. It is already an industrial site.
Well, I mean, part of it is, I think,
yeah,
there's a building which has expanded over the years with various planning applications, which is the core site, as you can see, the building area. But these panels are on a separate field. It's agricultural land rather than built-up land.
I think the point you were raising about the NPPF and major development, the development's there. The site is already there. I take your point about the greenfield and putting solar panels on it is a big change, but it's not quite the same, is it?
The planners have described it as
we're not into arguing. Sorry, answer the question.
Yeah. Well, I was asking.
What was the question?
Yeah. So it's the wrong intonation. So do you not think that that's just part of the overall development rather than a new development? It's part of the overall development, and therefore it's not the same as what you're saying for the NPPF.
It's on a greenfield site. There happens to be a building next to it.
Correct.
I mean, if I were to put an application in for the field next to my house, I couldn't just claim this part of the development. It's something completely different if it's not technically already built up. This is a new development in a field which is not currently built up.
I see. Thank you.
Yeah.
Thank you.
Okay, thanks.
Okay, I have two objectors. Felicity.
She's online.
Felicity's online.
She's online, sorry. Yeah.
And I'm Nicola Clark.
And you're Nicola Clark.
Yeah.
And which way are you going to take it? Because you've got 5 minutes between you.
Yeah, I'll go first. Just want to bring to attention this.
Sorry, you need to look your time down.
Okay, that's our house. We're fortunate enough to live in Thatch Cottage on Rosedown Drive, which is a tree-lined drive to the Technology Centre. The cottage is Grade 2 listed and over 500 years old. It's steeped in history, and as you imagined, we're privileged to live there, be custodians of it for our short length of life. The building is very much a living house, adapting with the weather and seasons. It continues to talk to us through expanding beams, wattle and door walls and old features. Such a house needs specialist care, breathable paints and sympathetic restoration to ensure it continues for future generations. Such a property would be sensitive to the creation of an urban heat island, the type created by solar panels. Our view of open pit fields and natural wildlife would be taken away. Wild birds and all the natural animals there. And no ecology report is going to say otherwise. And allowing such an expense to be built on would be sinful in an area of outstanding beauty. The carbon debt of the solar panels that they're proposing to use coming from Australia is unforgivable, along with the news that's been widely in the press about BP reducing their green energy investment. It seems farcical. This development is about greed with no regard for the local residents or wildlife. It has no benefit whatsoever to the local community, and the impact of the development would be detrimental to the village and the quiet lanes that surround it.
Thanks, Nikki. Hi everyone, I'm Felicity Quee. I live at Woodbury, which is another one of the residents that shares a border with the proposed site. I live here with my very young family and husband as well. So I just wanted to talk a couple of the concerns that all of the residents have been discussing. The first off is we were actually at this planning committee a few years ago when the car park that you can see in the pictures was approved. As part of those discussions and that debate, then a very large part of it was a sort of promise that they wouldn't be expanding the site any further, that going past the boundary of that bund that's already quite clearly there was the end of their boundary and the end of their extension. And so, you know, going past it again, once again, it just doesn't feel like it's setting a precedent for them to continue expanding, continue to grow across all of the different pieces of land that they own in this area. We also talked briefly about the viable alternatives that are out there. You know, this car park is huge. It's a 400+ space car park, and there's not a single solar panel covering it, as they seem to have legislated in all of the other countries across Europe, quite a few of them anyway. You know, they've got permissions again through this committee to build, rebuild, redevelop a number of the buildings. They're putting green roofs on them, but they're not putting any solar panels on them. I feel that a lot of the things that they could be doing to actually bring solar panels in a really green way is to use the existing infrastructure, to not go back on their promise to the residents to keep on building out further and further. And you know, this is a field where on one side of my house I've got the main road, and on the other side of the house I've got my garden, which is adjacent to the field. That's where my kids play. That's the space that we are right up against. And so this feels that they are just encroaching more and more onto the space of the residents. And if they genuinely want to build an industrial size solar farm, then is this really the right place for them, given that there's so many changes that are happening with BP at the moment, with their potential with their potential sale of Castrol, which is you know, all over the FT and Reuters and everyone at the moment. You know, there's a lot of change going on. It feels that they're doing this to improve the profitability of the company rather than for any green targets. Thank you.
Thank you very much, Roslyn. One question from me. I'm not too sure exactly where you live. Could you?
Well, yes. If I may stand up here, we've got a little label here, Thatch Cottage. And Felicity and her family, their residence houses are here, and then there's lodges here.
So where's your cottage again?
Oh, it's here.
It's there.
Yeah.
Okay. All right. Thank you. Committee, have we got any questions?
Sorry, can I just ask a question? So, while you're there, is that a bank of trees going across if you come down south?
Yeah.
Is that a bank of trees going through?
Well, I think that's what they're proposing. There's not there.
Oh, they're not there?
No, not at the moment. There are some small shrubbery trees, but no, there's not a nice thing like that yet.
Yeah, okay. Are there any other questions of the speakers? I see none, so thank you very much for your time. Thank you. Right, we're back to Mr. Dragonetti.
Well, and we've got the supporter.
No.
Oh, right.
How many speakers they?
So which way are you going to play it, Peter?
Oh, well,
You're going over there again.
yes, more council, right.
You're doing the walk council bit.
I guess. That's fine. I thought I'd be hearing a BP explaining how they how they've expanded their site over the years, and each time they come up, they increase their site. They say it's going to be the last time. Increase the car park from 250 years ago, so now 450. That's what they claim is recreational land. It's actually was mowed for hay until a couple of years ago. So it's a bit of a sort of cuckoo in the nest, isn't it? This industrial site in the middle of the national landscape, growing bigger and bigger, and easing out other residents and other nestlings to create this large industrial site in the national landscape. And where does it end? They bought this field. They bought the one further up that's outlined in blue up there, and when you read their literature, they're very keen on their site in Pangbourne, which of course is not in Pangbourne. It's in Bangport's in Berkshire. This is Oxfordshire. But they claim they're in the middle of the countryside, and the people who work there do enjoy working there because it is such a nice area. They do contribute a lot to the traffic over Whitchurch Bridge and through Whitchurch Village. And I think they come to a point at which one should respect the national landscape and allow it to remain an attractive and natural landscape, and not a industrial zone with all its adjuncts, such as this. Thanks.
Councillor Roberts, the question.
Yeah, I'm not an authority on solar farms. How with the Green Party? Do they support them?
You'll be pleased to know that planning isn't a political issue.
We're not allowed political science information. We know where you're going, but it's not a political issue. Okay, no more questions. Thank you, Peter.
I'll speak to you afterwards, Mr.
Yeah. I take it from that you will not be voting on this one either.
I'm entitled on the Constitution.
Don't remember what you just said.
I think that disrespect is a war against them.
Right, where are we going now? We're going back to the planning officer for questions. Councillor Sadler.
Hi. So Elizabeth Queen, Felicity Queen, I believe, the collector, was making some very good points there, which were very persuasive about it being an industrial site, fair enough, and about covering the car park and all those good things, and about, crucially, the conditions that were put about beforehand when they applied for the car park. I mean, I hadn't really appreciated that. I suppose if I'd read all the previous history, I might have known, but it sounds like there were some conditions, and that's a really good point, isn't it? Could you just answer that one? Because it seems like if there were some conditions on the car park that, yes, we'll let you have the car park, but please don't do anything with the field, please protect that, then it kind of puts this whole thing into jeopardy, doesn't it?
I can't comment on any promises that were made at the time. I'm just the planning application for the expansion of the car park was 2014. So I can just check the decision notice if that's okay. And the decision notice itself will just contain conditions saying the development has to be carried out in accordance with the approved plans, lighting, treatment of hard surfaced areas, turning areas, a green travel plan for the site, which I think the site operates by in terms of all of its staff trying to promote sustainable forms of transport, surface water, landscaping, protection of trees, protection of ecology. I don't think it would be right for a decision that there's nothing else there that would say that no further development could take place at the site, if you like.
I realise I've kind of put you on the spot there, and it's probably difficult to find those conditions, but I'm just concerned that if they're
I think these haven't been conditions, they've just been assurances by BP to sort of for local residents and the parish council and things, but it's they're good for us as long as they're application.
Yeah, okay.
I mean, most recently I dealt with the application to the battery testing facility, which was some additional buildings over the far western part of the site. So there's constantly been improvements to, because a lot of the buildings there are very old, the sites that started in the 1950s. So most of them have asbestos in, they need removing, replacing, modernising. So I dealt with that application.
Can I just comment here, because we actually need to look at this application, not previous applications, not what's gone on in the past. It's this application and what this is moving forward.
The question was about conditions, and if we go back to the previous one, where it's fine, we'll allow all these things, but we'll put some conditions in place, and then there's this whole variation of conditions.
I think we've covered that. There weren't any, right? Okay. Councillor Gordon-Creed.
Thank you, Chair. You said, Amanda, that there were no other options for these. Could they consider any other options?
Yeah, they did. They did a full assessment of all the site that they own, which is the application site is basically the small section at the bottom where the panels are contained. The area of blue line shows the other land that they own. And they did investigate all those sites. I mean, in terms of a lot of them were on the same grassland, but there will be constraints such as proximity to local residents, proximity to the civil ancient monument, trees, and openness as well. For example, over on the eastern side, the site is far more open to the public right of way. And this is considered to be the most appropriate site in terms of it being enclosed by woodland and the road to the west.
But did they consider covering the car park?
Oh yes. So they looked at various options on the site, and they did look at covering the car park. It didn't provide them with sufficient surface area, and also that in itself. I mean, it's not the scheme that's in front of us at the moment, but that in itself would be higher than these panels, which are going to be 1.1 metres from the ground, which are actually significantly lower than a lot of the standard solar panels that you'll see on other sites, which are nearly 3 metres. So that in itself would have a landscape impact. So it has been dismissed on those reasons, and it's set out in the justification for the proposal.
Councillor McDonald.
Sorry, I actually have a question on the application in front of us. Just a quick one, really. And damage is mentioned in one of the councillors speaking, and I just want to check. So the structures are supported; they're not putting pressure on the ground. Is there any adverse, significant harm to the underlying soil and structures by the implementation of solar panels?
They are ground mounted, but in essence, they are temporary by nature, so they could be removed.
They're not putting a lot of pressure on the soil or causing.
No, it's on a sort of a rick-rack sort of system, which would have supports in corners and concrete supports which would go into the ground, but those would be relatively.
And could increase the number of microhabitats, fiber structures, and it's sort of observation.
I mean, in terms of the panels themselves, these are actually slightly lower to the ground than the standard ones that you would see on other commercial solar farms.
Thank you.
Yeah. Sorry, I'm reading it because it's.
Yeah. There will be a question here, Amanda, but a bit of a comment to start off with. My understanding was that they were originally asking for 40 years, and the compromise was made at 30. That is a long time. That's longer than I'm likely to be alive, but it's not forever, and that's good. And at the end of the 30 years, my understanding is that the panels have to be removed. I assume that also includes the plant on its base of 15 by 17. That needs to go as well, and the fencing that goes around that. Would you consider extending that condition? Because my understanding is that technology changes very rapidly. This is a very big area. It's 8.6 acres being covered by these panels. Panels have got a lot better in recent years, recent decades, as I understand it. And I just wondered whether the condition to remove the panels could be extended to two other circumstances. Number one, if the technology changed such that they became redundant, or if this particular facility was to close. Because part of the issues that I was reading about was that it sort of set a precedent for a much larger part of the site to be considered developed. But if this particular plant, my understanding is that they will be using the power from it in its entirety, was to close and disappear, then these panels, would no longer have their purpose and maybe could be removed in that circumstance too.
I mean, this application is proposed for 30 years. For more commercial solar farms, we've seen permission being granted for 40 years, but this one is proposed for 30. And we do have condition 14, which states that, should the development cease generating energy for a period of 6 months or more, the panels and supports, etc., should be removed in their entirety and the land restored to its former condition.
Okay, so you have got this.
Yeah, and then there's the condition that requires it gives its permission for 30 years, but within 29 years following the first sort of export date, detailed decommissioning statements required.
Mm-hmm.
Okay, I think that's all sort of covered, but it's Councillor Albert. Yeah, two questions. I did ask the speaker, Nicola Clark, about what looks like a bank of trees. Have we got anything in the conditions?
So this the slightly sort of round area is an area of landscaping that was already carried out some years ago by the Technology Centre. Which contains sort of some scrubland and also some trees as well. In addition to that area of planting that looks like a sort of a straight line with a hook at the top.
Yeah.
That's the additional mitigation planting that the applicant has proposed to try and reduce the impact of the development from the north and from Thatched Cottage. And additional planting is also proposed around the sort of north and western side of the compound as well. We've got conditions. So the landscaping plans have been supplied and a landscape management plan. There was some discrepancies with regard to planting densities, etc., and some of the species. So we've asked for those details to be resubmitted again under planning condition. So we require a brand new landscaping plan and another landscape management plan. And in assessing those, we'll make sure that they both tie up with one another and are consistent.
Could we put a height on the trees rather than we don't want little twigs in the ground?
Well, exactly. That's what that condition will do.
Yeah.
It allows the landscape officer who's made an assessment of the scheme and of the additional mitigation to make that judgment and to say whether they're going to be high enough. Because there's no point putting them in too small.
Well, second question, condition 5, the great crested newt. Has that taken place? Are there great crested newts on the land?
The ecologist has confirmed that there will likely be great crested newts on the site. There's a great crested newt mitigation strategy that has been proposed as part of the ecological assessment that the applicant's undertaken. And the ecologist is happy with the details set out in that. They will also need to apply for a derogation licence from Natural England, which allows them to carry out the development on the site. And it's sort of like a risk assessment if they actually come across any great crested newts.
Yeah, thank you.
Okay. One last question on the farmland. There seemed to be some doubt whether this was grade 3A, which is counted as part of the best and most versatile land, or 3B, which is slightly below that. Has any, since the reports have been done, has there been any further?
We don't have any further information on the specifics of the grade 3.
Yeah.
It's just our view that the development is supported by national and international, policy on solar development, and that the need is great.
Thank you. Okay, where am I going? And all the debate. Looking for a proposal, please.
I'm not an authority.
Yes, I don't think any of us are an authority on solar panels.
I'll listen to the debate.
I'll go for officer's recommendation.
Thank you. Thank you. That's seconded. Thank you, Councillor Popping. Okay. Right, I've got to say, do you want to speak now or wait or reserve your right to speak? Or I'm going to go back to Councillor McDonald to speak.
Oh, I'll speak now.
Okay, wait till the proposal is spoken.
Just very quickly, I can see that if this went to appeal, he would part. Looking at the detail of the mitigation, the part of the trees, looking at the sizes and so on, that seems to satisfy the officers. I'm not an expert at saying these are the things. But that seems to satisfy the issues maybe with the residents around. In terms of damage to the land it's on, again, I'm reasonably content with the fact that even after 30 years, the land could then be used as farmland quite readily again. The large structures easy to place and easy to remove. And visually, I appreciate there's an issue, but I've already covered the fact that there's some planting to try and mitigate that. And that's where I'll leave it at the moment.
Okay, Councillor Topping.
I think my main reason for support has been reinforced by what Amanda pointed out to me, which I'd missed, was that if they don't use the panels for a 6-month period, then they could be asked to remove them. 30 years is a long time. As I said, it's longer than I'm likely to be alive, but compared to, I think the lady who spoke from Thatched Cottage, her cottage is 500 years old. In the context of that, 30 years isn't a very long time. And as long as this can be removed, if it's not used and needed, and in any event, at the end of 30 years, my view is that this is the sort of development that we should be supporting to help a facility that employs people in our area. And presumably will keep that centre open for longer with the investment that is being made as a result of this. And looking into new battery technologies is something probably that we should be doing and supporting.
Okay. Well, is there any debate, Councillor Summer?
Yeah, I mean, I think reading the report, I was fairly satisfied that it was a good move, put solar panels there. I am talking about this section, so yeah. And it is a shame, really, for. I did really feel for Felicity Q when she was talking about the other options that might have been available. It does sound like they've been exhausted, to be fair, but I mean, yeah, it does. It is a shame that such a large piece of green space is going to be lost as a result of this. I hadn't appreciated it was quite as old as it is, but yeah, I think on the whole, yeah, I would tend to agree that 30 years isn't that long in the scale of things, and it's a shame, but I think it's for the right reasons, and I think solar power generation is the right thing to do. I don't really agree that it's greed by the people who are putting it there. I think they're trying to do the right thing. So I think on the whole, we probably should support it.
Okay. Any more debates? Elsie?
I guess for me, the thing that I heard as well, there were two things that didn't get addressed, but I wish that would have been, would be the community benefit. Although I will support this application, but for me, the fact that it is only serving the installation and it is in the national landscape, I think someone who lives in the area should really benefit. If we're going to be made to approve these applications with renewables, then I think there should always be a community benefit associated with it. But that's not what is before us, so never mind. But in principle, yeah, I wish there'd been another way to do it, but this is the application, and yeah, it's
Okay.
as good as it can be.
Yeah. I think I'll go to Councillor MacDonald to sum up.
Nothing else to add to that.
Okay, we'll go straight to the vote then. All those in favour of the proposal, please show. 6, all those against. Abstentions. That's one. Okay, so that is passed. Right. It's 8:10, so I hope we've got time for this one, which is 23 S1202. Yeah. On the states, there's been some digging on solar panels, and we'll try and everyone to China. So they will go to time. Sorry about Matthew. Right, Paul Bowers. Not the Whitchurch show anymore, it's the Paul Bowers show.
Thank you, Chair. The application before members this evening is your office's recommendation to grant planning permission conflicts with the parish council's recommendation that the application should be refused. Just to update members, the council has received a further objection to the application since the publication of the agenda, highlighting concern over parking on the highway. The application seeks planning permission to demolish the existing 1.5-storey dwelling and replace it with 2 detached 1.5-storey 4-bedroom dwellings built in brick, render and cedar panels. The site is located in the Greenbelt and within the built limits of Holton. In respect of housing and Greenbelt policy, this redevelopment of the site accords with the respective policies both at a national level and local level within the local plan. The development provides for 2 off-road car parking spaces, each in addition to 2 visible spaces in excess of requirements, thereby mitigating the impact of potential indiscriminate parking on the adopted public highway. The triangular nature of the plots mean that there is the potential to overlook the next door property at Carina. However, first floor windows on plot 2, nearest the shared boundary, have been omitted, and a condition is proposed to ensure that any additional windows will require planning permission from the council, allowing the council to control in the future. The design, height, position, and scale of properties differ from other properties in the area. However, there is no one uniform design. The area is characterised by properties of different design, size, and material, and as such, the 2 new properties add to the existing mixture rather than detract from the prevailing established design and character. This development must be considered in the context of the tilted planning balance, where planning permission should be granted unless any adverse impacts of doing so will significantly and demonstrably outweigh the benefits. In your officer's view, there are no such impacts. The development complies with the relevant development plan policies, and therefore the application is recommended for approval. Thank you.
Thank you, Paul. Okay, number of speakers. Chris Roerig, is that correct? And you have 5 minutes starting as soon as you start speaking. Speaking. You have 5 minutes starting when you start speaking.
Thank you. Yes, I'm a resident of Holton, and I've tried to represent the range of a local opinion in this presentation. Our objections are in three main areas. Firstly, the principle of the development. The proposal is for the demolition of a building and its replacement with new structures. However, it's surely accepted nowadays that doing this has a highly disproportionate impact from an environmental perspective. Recent reports from bodies such as the Commons Environmental Audit Committee, the Royal Academy of Engineering, and the Royal Institute of Chartered Surveyors urge that older properties should be reused rather than demolished. While the Aviary, like many houses in the village, is an old one and an attractive focal point, we see no compelling reason for its demolition. And we remain of the opinion that an acceptable solution could be based on the existing structure. The second area I want to go into is the impact of the development. While the applicant states that the existing building is 2 stories, it really takes the form of a bungalow with the roof conversion. The proposal is for this to be replaced by a pair of real 2-story buildings, including roofs. So they will be much higher than the existing structure. It should also be noted that this site is significantly raised, and the existing building already sits at an elevated level compared to its surroundings. This photograph, taken from the properties across the road at eye level, shows the relationship between the existing building and the properties on either side. The planning officer's report agrees that the new buildings will be prominent, but states that the main impact will be to the properties on either side. And it's certainly true that both these properties will be faced with large gable ends close to their boundaries that were not there previously. But this is only part of the case, and we're concerned that the impact on properties on the other side of the narrow road through the village has not been adequately considered. Referring to this photograph, a consistent line of the roof levels of the existing building with those on either side can be seen. And it's very clear that adding 2 large houses with an extra story will have a very significant impact. We would expect that there will be a far greater visual impact, but that's suggested by the planning officer's report. Thus, we consider the proposals will in fact create a material harmful impact to the existing character and appearance of the area, and it's difficult to accept the officer's conclusion otherwise. Neither can we agree that the properties will be modest and unobtrusive as described in the planning application. Moving on now to the question of vehicle access and parking, and perhaps I could have my next slide up now. While the report from Highways state that there is an adequate space for vehicles and access, we are concerned about the practicalities of this proposed layout. The assumption is 3 spaces per house, but with 1 space for plot 1 being located at the far end of the site, adjacent to the plot 2 parking. Unusually, there are no garages in these properties, and to allow full access to vehicles, it will be impossible to park anywhere other than these designated parking areas. Thus, the apparent generosity of the space of vehicles will not lead to as much amenity as might be expected. And this could in turn result in the temptation for on-road parking, which, owing to the nature of the road layout in this area of the village, would present a road safety hazard if carried out at the frontage of the property. Could I have my next slide, please? And this shows the boundary of the property in red there.
30 seconds left.
On a narrow road close to a sharp bend. Thank you. So we conclude that plans to shoehorn 2 large buildings into a place where a single-storey cottage was located will go against the preferred environmental practice, be out of sympathy with the general neighbourhood, adversely affect the amenity of neighbouring properties, and potentially lead to practical difficulties in terms of provision for vehicles. Much of this is caused by the compromises needed to accommodate 2 houses, and Holton Parish is not in need of 2 houses of this nature,
especially with a 500 house development already progressing in the parish at the old Brooks University site.
All right, the time is up.
Okay.
Right, thank you, Mr. Rowling. Chris, have we got any questions?
Yeah, I'll go for one.
Yes, okay, Councillor.
Just looking on Street View, and it's very hard to tell whether the bungalow, the chalet bungalow, is actually the same height as the neighbours ones. I know you've shown that on the picture, but it's very hard to tell. I mean, could that just be sort of photography?
Yes, I can appreciate that being a view. What I did was stood across at the opposite side of the road at eye level with my camera and literally took that photograph. I then put my camera down and I can assure you that is what you see.
Okay.
The ridges of the new building will be approximately at the level of the existing one. So I wouldn't imagine there'll be any material difference in that. But of course, they'll be higher.
I see. Okay. Thank you.
Okay, thank you, Mr. Rory. Final speaker this evening then is Jake Collins, who's the agent. You have your 5 minutes, Jake, when you start speaking.
Chairman, members of the committee, can I thank you very much for the opportunity of addressing you this evening. You do have a full and comprehensive report before you from the planning officer recommending that planning permission be granted, and I would commend that recommendation to you. I do, however, want to briefly touch on some of the key planning issues raised by the proposals and also respond to some of the comments made by the previous speaker. In terms of matters of principle, the site is not located in the conservation area, nor is the building listed. That being so, there are no planning constraints to the demolition of the existing. Moreover, policy H1 of the adopted local plan accepts, in smaller villages such as Holton, the principle of infilling. The site and the proposed development, in being closely surrounded by existing buildings, comprises infilling as defined in the local plan. That being the case, the principle of the development is consistent with the spatial housing policies of the plan. Moreover, and notwithstanding that the concept of the grey belt would apply to the site, the proposals also comprise limited infilling in an existing village. That being so, the scheme also constitutes one of those forms of development that the National Planning Policy Framework identifies as being appropriate and acceptable in the green belt. The site is otherwise located in a residential area of mixed architectural styles and forms, although on the northern side of the road, the dwellings are generally 2-storey in scale. The height of the proposed dwellings would be directly comparable to those the other side, or either side. And just in response to what we've heard from the previous speaker, I have indeed measured the heights of both of the adjoining buildings, which measure at 7.1 metres and 7.3 metres to ridge, respectively, and the proposed dwelling would be 7 metres to ridge. Whilst I acknowledge that the buildings would be sited marginally forward of the neighbouring properties, albeit over the footprint of the existing dwelling, the dwellings along the northern side of the road have a varied and stepped relationship and alignment with the road, with which the proposed layout would be entirely consistent. To that extent, and given that the design of the proposed dwellings would provide a sympathetic addition to the mix of styles currently evident, the proposals would fully respect the built character of the area. In addition, the scheme has been sensitively designed to ensure the amenities of the directly adjoining properties are, in terms of matters of light, outlook and privacy, fully preserved. Furthermore, a high-quality living environment would be provided for future occupiers, with private amenity space delivered to a level far in excess of the design guide standards. As per the conclusions of the Highway Authority, the alterations to the existing access will be fully compliant with the requirements, with appropriate levels of parking provided. And again, as mentioned by the case officer, dwellings of this size are required to provide only 2 spaces each, and there's an additional further 2 spaces provided on site, 6 spaces in total, more than required. Moreover, there are no ecological, flooding or drainage constraints, with a net gain in biodiversity secured and compliance with the Council's carbon reduction policies also demonstrated. Accordingly, I would commend the recommendation to you. Thank you.
Thank you, Mr. Collins. Quick, is there any questions? Councillor Albert.
When you say the height is 7 metres, is that from DPC? And if it is from DPC, the measurements you gave either side, are the DPC levels the same?
If anything, the DPC levels on the adjoining properties are already higher because the ground is sloping away from the road and those buildings are set back from proposed dwellings. The measurements I took were from ground level as illustrated on historic planning drawings for both the adjoining properties and likewise from proposed planning drawings. So if anything, I'm possibly underestimating due to there is a slight differential in level as the neighbouring buildings are constructed on a slightly higher ground level.
Thank you.
Councillor Topping.
Yeah, also on height, you talked about the proposed buildings and the 2 adjoining buildings and demonstrated that the height might be slightly less. But what about the height of the existing building that's on the site? Because I was slightly confused at the intro in Paul's report that talked about the new buildings being 1 3/4 storey. And it was just to compare, what's on the site at the moment with what is proposed. What is the height difference?
I don't have an exact figure for that. What I can tell you is the proposed buildings are higher.
They are higher than
what's there, but no higher than what's currently either side.
But still lower, arguably, than what's on either side. Okay. And do you also the age of the existing building? The neighbour who spoke earlier said that it should be kept and restored or converted. What sort of building are we talking about? It's difficult to tell from that photograph. What sort of age is it?
And I have to tell you, it's equally difficult when you see it on site because there are lots of different component parts to it and various extensions over time. So I'm no heritage expert. I confess, so I'm not going to even hazard a guess at a date.
I don't think that's relevant.
Okay.
Okay, thank you, Jake. Before we move on to question for Paul, 8:25 +8. Actually, the witching hour, so we have to agree to carry on to finish this.
Yeah,
on the agenda. Okay, Paul's agreed. Okay, thank you. Right, we're going now to Paul for questions. If I didn't do it, I'd get reminded, wouldn't I? We have no questions. No, okay, there's no questions. I'm looking for a proposal.
Suppose we go with Of's recommendation on it.
Thank you, Councillor Gordon Creed. Is that seconded? Seconded by Councillor Topping. Where am I going now? I'm going to you for your opening statement.
All the issues that I had were answered satisfactorily, and I feel that the report gives us all the information we need. But I would go with the proposal.
Is there going to be any debate? I don't. Councillor Sadler.
Yeah, I feel for the residents of Bolton. I think it's always a shame changing the landscape, and I think overall, I think the benefits outweigh the loss in terms of in terms of new building, probably much more efficient, and I think in time they'll get used to it, and I think they'll be happy that the changes occurred.
Yeah. Councillor Topping.
I mean, the point that I wanted to make, and you did probably, I'm sure, quite rightly stop me that it wasn't appropriate in the context of talking to the agent about it. But I think it is important to focus in on what's there at the moment, and what could have been done with what's there at the moment and what it's being replaced by. And my belief is that what it's being replaced by probably is better, but a little more information on what is there would have been helpful, I think, because we haven't had a site visit on this one, so I haven't had, the opportunity to really, look at what's there and form a view as to whether or not there was any meaningful opportunity to restore or extend or improve what's there. I get the impression from what's now being said in terms of the fact that it's been extended and messed around with over many years, that we're going to be ending up with something that's significantly better. And for that reason, I'm seconding it and supporting the officer's recommendation.
Okay, thank you. Is there any debate? Anybody else?
Yeah,
Sorry, go on.
I just think it's a bit of a shame. I don't know what the existing. I'd be interested in how old the existing house is, or what it really was. But I think just looking at these two houses, you know, they're straight off a CAD design, aren't they? They don't, you know, respect. You know, there may be other houses on the road which will have varied in character, but these are two pretty, you know, straight off the computer design. And I think it's a pity we haven't. The opportunity has been taken for doing something slightly better, slightly more interesting, rather than having a pair of identical houses there. That's my view.
Councillor,
I think as Adrian would tell us, we're not here to redesign a property.
No, but we can still make a judgment on the design because we can refuse.
you can refuse it on design.
All I would say, Chairman, I don't think I've ever seen a section of land like that before. Two houses sitting on it. But then again, that's no reason for refusal. I'll be supporting it.
Okay. I'll go back to Councillor Gordon-Creed.
I agree with Councillor Dragonetti on the design. I wish it was more sympathetic to the age and character of the village, but I think we will end up with a much more energy efficient living space ×2. And I think it's been done as well as it could be done given the unusual plot. So yes, I think.
Okay, all right. So we have a proposal for officer's recommendation. All those in favour, please give. All those against? That is a vote. And we're already just at past. So we've got the appeals started, including enforcement appeals and the appeals that have been heard. And one's been allowed.
I'll propose to accept that.
Okay, thank you. I've only got one other thing to say, and many of you will know already that there's an extra meeting we've agreed to. It was on the 2nd of July. Yeah.
Stop looking.
Have to get subs in, please.
Got called. Bertie, can we stop the stream, please?
And a huge apology for me for missing